There we go. So we'll talk about abatements. We'll expedite this presentation like I indicated earlier, so we stay on time. So we're going to talk about a little bit about the basics, then zones and abatement process, some important details, and the comptroller role in all of this. Here we see some basic numbers, and we'll talk about the numbers later on, but some basic numbers about abatements, current number of abatements that are actively assigned. And you'll see the numbers have gone down. It's not that there's necessarily fewer cities and counties giving abatements. It's that over the last couple of years, our office has made a special effort to clean up our list in terms of what is active, what is not active, what is inactive, and so forth on. So there are 653 currently active assigned abatements. The number of reinvestment zones, active versus inactive. We have 239 active versus 2 inactive. And when I say inactive, that means maybe someone's submitted a report, it was partially filled out, it gave maybe a start date or an effective date, but it didn't give an end date or an expiration date. And so our computer system, our E-system, can't read that. And so it defaults to 1900. And so there are a couple of those that are quote unquote inactive, and we're asking local governments to correct or update their data in those instances. We have enterprise zones. As I indicated earlier with regards to TERSs, there's distinctions in types of zones. There's TERSs, there's traditional reinvestment zones as authorized under Chapter 312, and then there's enterprise zones as authorized and reconfirmed under Chapter 312 of the tax code as it relates to enterprise zones. And enterprise zones are something in which cities and or counties can work with the governor's office to create an enterprise zone. Normally, when you create an enterprise zone, the local government and the governor's office use the Census Bureau data. And Census Bureau data shows blocks and tracks. And so when reporting all this information, you'll have to report the block and track number as assigned to it by the Census Bureau. So keep that in mind. And then there's the number of active and inactive TERSs. As we indicated in the TERS presentation, TERSs can approve abatements. In a very few instances, there are TERSs that have approved abatements. And as you see here, there are 2 TERSs that have approved of abatements. We'll go through some quick numbers here. Base value of abated property is nearly $8 billion. New FTEs is approved by or created by abatements. We're talking about 84,000 new FTEs. These are jobs that have been created. And when at that top, you see from 2016 to 2034, why a 20-year period? Well, because you could have an abatement going from, say, 2016 to 2025. So the abatement is currently in its last year of the abatement right now. And so it's showing all those numbers. And then you could have an abatement going from 2025 to 2034, which would be another 10-year period. And so it would show those numbers going forward as well. Payroll dollars created, we're talking about a little over $2 billion of new payroll dollars, dollar amount given to the business in terms of talking about $230 billion, number of businesses receiving an abatement, 729, number of cities giving an abatement, 80, number of counties, 73, number of CADs reporting the abatement from cities and counties being 98. So what is an abatement? An abatement is basically an exemption from property taxes, be it real and or personal property, for a period of not to exceed 10 years, and this can be in part or in whole. The purpose of an abatement is at least one of these three goals. If it's for anything else, then you need to reconsider what you're asking for, what you're trying to do. The purpose of an abatement is to attract the business, typically from out of state, to come to your community to bring jobs, good paying jobs. That's reason number one, to bring in a company or use an abatement. Reason number two to use an abatement is to encourage existing businesses in your community to further grow, hire more people, give better paying jobs to people, things like that. That would be the second reason to give an abatement. The third reason to give an abatement is to encourage businesses from wherever to make significant capital investment in property there in your community. Those are the only reasons to give an abatement. This process here is basically the same process as you saw under TERS's. At any time in the year, an abatement can be passed. And our example is July 1 of 22. In August of 22, the lead taxing unit begins the budget process and setting the tax rate. In September of 22, the budget and tax rate are set by the lead taxing unit. In October 1, the budget and tax rates take effect. In January 1 of 23, any abatement agreement typically takes effect. Typically, not always, but in the vast majority of instances, it takes effect at the beginning of the new year as approved of by lead or by the local governments creating or approving the abatement. May 1 of 23, the property owners get a notice from the appraisal district. This will show any exemptions known to the CAD, including abatements. October 1 of 23, tax bills are sent from the CAD to the property owners. January 31 of 24, property taxes on the business are due. And so again, this is where you'll see a full year go by before the abatements become realized and are then remitted back to the taxing unit. We have a question. Go ahead, Jake.
Lori Jackson asks, she's wondering what you know about the payment in lieu of taxes, quote, pilot abatements.
I am not familiar with that. Under tax abatements, there's no such wording in Chapter 312 of taxes paid in lieu of. So you might want to check with our property tax office on that, if that is something that they're familiar with. There's a handful of steps for local governments to go through to get through to approve an abatement. Step one is to adopt the guidelines and criteria. Think of guidelines and criteria as the rules to play in a game. If you're going to play like Monopoly, you need to know the rules. Here you're setting the guidelines and criteria on what the rules are that the city or county that is wanting to play the abatement game, what they're going to give to local businesses, what they're not going to give, at what level, what will be considered, what are the requirements of cities or businesses in terms of number of jobs, in terms of payroll or other incentives that they're trying to encourage businesses to provide. So those need to be adopted right out of the gate. So you would develop the guidelines, you would hold public hearings. To hold a public hearing, you need to send out a public notice, a minimum of 7 days advance of the public hearing when you send out the public notice. You would need to adopt these, which are good for 2 years, and then reauthorize them for an additional 2 years. If you fail to reauthorize them prior to their expiration, then the guidelines and criteria expire, and that will prevent you from approving new abatements. So make sure you reauthorize them before they lapse or expire. And then the adoption of the resolution. Go ahead, Jake.
I think we have a question and a comment, but Bobby Wynn says, can a real estate developer apply for an abatement?
Any business can apply for an abatement to the local government. It is up to the local government to determine if it is reasonable and feasible in their interest to give an abatement or not.
And Lori Jackson, following up on that, was saying that they have 3 battery storage facilities that are coming to us, and maybe the pilot. So I would say maybe just reach out to PTAD people.
Yeah, I would encourage you to reach out to our property tax office with regards to that. So moving on, the criteria, as you see this criteria pop up, you'll notice how not just similar, how exact it is, with the exception of one thing, as you saw under TERS's, such as substantial number of substandard or deteriorated structures, defective, inadequate sidewalk, streets, the value on the property is upside down in value than, or more is owed on it than it's worth, poor platting, unsanitary, unsafe conditions, deterioration of site improvements, defective, unusual conditions of improvement. All these are the same statutory language as you saw in Chapter 311. The only difference was that last bullet under 311, where there was danger of disaster or fire. That was the only exception. So if you have at least one of these criteria, then you can create a zone. If you don't have one of these criteria, there are other opportunities, but you must meet 2 or more of these, such as being a federally assisted new community, being a federally assisted new community located or adjacent to one in a home rule city, where there's obsolete platting, unsightly signage, where there's too many signs or billboards that you want to get rid of or remove. And this last reason is been cited to me by a good lawyer friend of mine who works with a number of local governments that have done abatements, and that is where it is reasonably likely to contribute to the retention or expansion of primary employment or attract major investment in the zone. So if you meet a combination of these factors, then you are good to go. Step 2 is the designation of the zone. And again, you must provide a public notice, minimum 7 days advance notice, minimum. You hold a public hearing, give adequate opportunity for those for and against to have their say at the public hearing. The adoption and renewal of the order or ordinance. If the zone, when you approve a zone is good for only 5 years, which means if you're still wanting to participate in the abatement game, you need to renew it before it expires or lapses. Otherwise, you're going to have to restart the whole process all over again. If you're doing an enterprise zone as authorized under the government code, you would follow the same steps here, same steps as creating a normal traditional reinvestment zone. And then you would go online to the Comptroller e-system, assuming the zone is approved. You would use the e-system e-forms to fill out the required data to report the creation of a new zone or the renewal of a zone. So you would then do a resolution of abatement eligibility. This is separate, done at a separate meeting, separate day from the approval of a reinvestment zone. The resolution must be considered at a separate meeting from the zone and considered voted on. The resolution is to state that the taxing unit elects to become eligible to participate in a tax abatement. A city or county should give notice to the public and other taxing units with jurisdiction over prospective abated property, indicating intent to pursue abatements and or receive abatement applications. This also affords those other taxing units the ample opportunity. You want to give them ample time to put on their agendas to consider giving an abatement, because you may have a significant company wanting to come, considering coming, and you may need a package of offers from 2 or more local taxing jurisdictions and put a pretty little bow on a series of agreements to entice them to come to your community. Step 4 is the abatement public notices. And here, by statute, as approved in 2019, you must give a minimum 30 days public notice of the intent to have a public hearing. The public notice must contain the following things: the name of the property owner, that would be the party to the agreement, the name and location of the zone in which the property is located, a general description of the improvement, and the estimated cost of the improvement in the agreement. Entering into the abatement agreement is step 5. You'd hold a public hearing, give ample opportunity for those for and against, review and consider the terms of the abatement. And then there's what I call the 7 prerequisites. And the 7 prerequisites, as outlined in statute, are: list the kind and number and location of all the proposed improvements, limit the property's use consistent with the taxing unit's development goals, provide access to and authorize the taxing unit to inspect the property to ensure compliance with the agreement, allow the taxing unit to cancel or modify the agreement at any time if the property owner fails to comply with the terms of the agreement. Those are just a few of the 7 prerequisites. Then there's the approval and submission of the new abatement agreement online form. So assuming the local governing body has voted on and approved the new abatement, you would go to the comptroller website, fill out the e-system online form for new abatement agreements. Step 6 is the post-abatement reporting. And here, reporting on the post-abatement appraised values on property for an expired abatement. So if an abatement is good for 10 years, you're going to be required to have a post-abatement report for 3 consecutive years. The first report being due 1 year, 1 full year after the abatement's expiration. So here in the example, we see the abatement expires December 31 of 2020. The first post-abatement report is due December 31 of 2021. The second is due December 31 of 2022. And the third and final post-abatement report is due December 31 of 2023. We talked about zone naming under TERSIS, and it's basically the same exact thing. And so you're going to format it. You can include any of these as part of the name. It must include either the business name, the community name, or the subdivision name. The second part of that, it must indicate if it is a reinvestment zone or enterprise zone. Or the third one would be TERS in those few limited instances. If you're showing that, and you would only record that when reporting as a reinvestment zone under the abatement reports. You must provide the numbering of the reinvestment zone if applicable, if there are multiple zones. So if you have 2, 3, or more, you could say zone 1, zone 2, zone 3, zone 10, 11, 12, etc. You must provide the tract and block numbers if it is an enterprise zone. You must. You should not, under any circumstances, provide any of this information in the name of the zone, such as dates, abstract numbers, orders or ordinances, CO or LLC in the name of the zone. As you see here are some examples, good examples of a properly formatted zone, such as Samsung Zone, which would be the name after a business. Denton County, Zone 1, that for that of a county participating. Rodeo Drive Reinvestment Zone for perhaps a subdivision. City of Houston Reinvestment Zone number 18, indicating a city with perhaps multiple zones in their community, things like that. And if you have questions as to tract and block numbers, I suggest calling or going to the governor's website to find out tract and block numbers. Keep also in mind that census and tract numbers change every 10 years because the Census Bureau do their numbers every 10 years. And hence census and tract numbers will adjust, and hence census and tract numbering as done by the Census Bureau may change every 10 years. So who can create zones and abatements? Well, cities, counties, and school districts can create reinvestment zones, can create. The reason why I have school districts there is that school districts that participate in the JETI program that Desiree spoke about at the very beginning of today's presentation are required to create a reinvestment zone, which means they need to go onto our website to create the zone. After that, they don't need to do anything more under the Chapter 312 website. They may need to do other reporting requirements on the JETI website, but not under the Chapter 312 website. And then there's abatements. Only cities and counties can give abatements, as well as special purpose districts. And these would be potentially the list of special purpose districts that can participate and give abatements. So let's think about a 10-year period as to when an abatement agreement would last. If it is executed or signed in September 10th of 2023, that means the effective date can be perhaps something along this line, September 10, 2023, or later, not before September 10, 23. So in our example, we're going to use January 1 because that's how most taxing units would set their effective date beginning at the beginning of the year, as we mentioned earlier. Then there's the expiration date. So if the abatement takes effect on 2024, 10 years later is not 2034, that's 11 years. It will end December 31 of 2033. That would be the 10th and full year of the abatement agreement. Also keep in mind our construction supply chains delays or issues. So when the comptroller's office is asking you to submit a report on a newly approved abatement, keep in mind the effective date. The effective date of the agreement should begin when all construction is complete and there are no more construction issues, no more supply chain issues, things of that nature. So what is the comptroller role in all this? Well, the comptroller role, as I indicated earlier, are these three things: maintaining a central registry for reinvestment zones and abatements, submitting a report to the legislature and the governor no later than December 31 of each even-numbered year, providing technical assistance. Again, that could be answering your phone calls or emails, responding to requests to do presentations in your communities if we're able to, or holding webinars like this. That is providing technical assistance. The reporting requirements. First, there's the guidelines and criteria, and all this is on our e-system e-reporting tool. So first off, you're going to have to fill out the online form, and then submit the order ordinance and the guidelines and criteria. Those are going to have to be submitted not separately, but attached together as one single file. Otherwise, the system won't accept them both separately. So keep that in mind. These are due by July 1 of the year following the year in which the guidelines and criteria were approved. Then there's the new reinvestment zone. And so you would go and fill out the new reinvestment zone, as well as the redesignation or renewal of the zone. If you're renewing the zone, because keep in mind, they're good for 5 years, you'd fill that out. And then you would upload the following documents, such as the meets and the bounds and the abatement resolution, and attach that as a single file and submit those by or before July 1 of the year following the year in which the zone was designated or reapproved. That brings us to the abatement agreement. So if you are approving a new abatement agreement, you would go online again, fill out the new abatement agreement e-system form online, and then you would attach a signed copy of the abatement agreement. If you're not attaching a signed and dated copy of the agreement, and it's just blank in that sense, then there is no approved abatement agreement that you are reporting to us, and we and the public will see that. So make sure you're submitting a signed and dated abatement agreement, as well as the order or ordinance that approved the abatement agreement. This too is due by or before July 1, the year following the year in which the abatement was executed. Executed, not effective, but executed. We have a question. Go ahead, Jake.
Christine Thomas asks, if there is a reinvestment zone created by a county, does the ISD still have to create a zone for them to participate in a jetty in the established zone?
There's two different points to that. And that is, if a county has created their own zone, then no other taxing jurisdiction, including the school district, can use the county zone. If a city creates a reinvestment zone, they would then be considered the lead taxing unit, and no other taxing jurisdiction can use their zone. So if a school district is doing a jetty agreement, then they need to create their own zone separate from the other taxing jurisdictions, and then report that to us. That's how that would work. As it relates to a modified agreement, the modified abatement online report would be filled out. You would attach a copy of the signed and dated modified agreement. The order ordinance would be attached, and again, these would be attached as a single file, and these are due by or before July 1 of the year following the year in which the agreement was modified. If it is a canceled abatement agreement, you would fill out the canceled abatement agreement online form. You would submit the order ordinance number that approved that cancellation, and that can be done by an abatement can be canceled by either the taxing unit or the business. If it's done by the business, all that would happen is that the local government would just pro forma recognize that that has been done. But if it's done by the local government, then the local government needs to formally approve a cancellation by order or ordinance. And that too is due by or before July 1 of the year following the year in which the agreement was canceled. So who's the reporting party in all this? It's the appraisal districts. The appraisal districts are the reporting party. But keep in mind, The appraisal districts at no point through this whole process has been party to any of this. The guidelines, criteria, the creation of the new zone, the approval of the abatement agreement, none of it. So they will not know any of the details. So that is imperative and incumbent upon you, the local governments, to get them all the information they need. And where can you find that information? You can go to the Comptroller's Chapter 312 website, where we have sample forms online in which you can review and see what questions are being asked of the CADs, so you know what to provide to them. It is your responsibility to provide those answers to them, because whatever the CAD sends, if it's right or wrong, is going to be made public, and it will not only reflect on them, but it will reflect on you as well. And then there's our traditional recommendation: within 30 to 60 days, you're doing all the hard work on all these items and approving all these items. So if you're able to, within 30 to 60 days after the approval, then we're asking you to submit those documents online. However, if you can't for whatever reason, or if there's construction delays or supply chain issues, then we suggest you wait by or before to submit July 1 of the year following the year to make those submissions. And you can find our online e-forms on this webpage here. And if you have any other questions, you can contact me at this number and email.